Hello, everybody. My name is Annie Grahl, and I'm the co-chair together with Liz Blackburn of Wisconsinites Abroad, the Wisconsin state team of Democrats Abroad. And if you're on this call today, you probably know that Wisconsin has a very important state Supreme Court election on April 4th. The court currently has a 5-4 conservative majority, but if Liberal candidate Janet Protasiewicz wins this election, it will flip the balance, giving the court a 5-4 Liberal majority. And we have a very real chance of winning this one. Turnout in the primary election broke records. And if we can keep that level of energy high for the next few weeks, things are looking very good. One group we're working hard to reach this year is college students who are studying abroad, because a lot of them are unfamiliar with the process. We've been explaining to them that UOCAVA law enables the voter to receive their ballot by email, whereas if you register to vote using the in-country vote by mail process, that ballot would be sent by postal mail. And there's simply no way it could be received, filled out, and returned in time. So a huge thanks goes to the teams working through Vote from Abroad and Rock the Vote to help students to vote in this election. And in that spirit, our speaker today, Professor Howard Schweber, is a University of Wisconsin professor and an expert on legal issues. But before I turn the mic over to Liz, I just want to mention these important deadlines. Registration for the general election for Wisconsin voters living overseas, the request must be postmarked by March 15th, and it must be received by your local clerk on March 30th. Ballots will be sent out by local election officials on March 14th. Note that this is different than the 45 days that are allowed by UOCAVA for federal elections. And for that reason, we are encouraging all voters to use the federal write-in absentee ballot, or FWAB, this time. Ballots in Wisconsin must be sent back by postal mail, and they must be received by April 4th, Election Day at 8 p.m. local time. So for the Wisconsinites on this call, if you haven't voted yet, please do. And for those of you who are not Wisconsinites but want to help, you can help us by making phone banking calls, by helping to answer emails with requests for information that come through on intercom, and by telling every Wisconsinite that you know how to vote. They can request a ballot in 5 minutes or less using votefromabroad.org. They can learn what's on their ballot by visiting the Wisconsin webpage on Democrats Abroad. That's www.democratsabroad.org/WI-USA. And to all the information they need about sending the FWAB back home is also on the Democrats Abroad website. It's www.democratsabroad.org/WI_FWAB. And Liz is putting those in the chat. And now I'll turn it over to Liz Blackburn.
Thank you, Annie. I'm Liz Blackburn. I represent Democrats Abroad China, the Disability Caucus, the Environmental and Climate Crisis Council, and the great state team that is Wisconsinites Abroad. Little about me, I was a rower on the crew team at UW-Madison. And this time of year, the lakes are frozen solid by feet. And then in April, things begin to thaw slightly, and we get out our gear, our ice-breaking gear. We break up that ice, and then we get rowing. No matter how dark or cold or early the morning is, we get out there and we row, because that's the Wisconsin way. Now, a lot of Wisconsinites feel the same way. They work hard, they play hard, and they expect their politicians to represent them and work for them. But Wisconsin politics have really been frozen in a Scott Walker rut. From the legislature to the Supreme Court, we find nothing but impediments to the progress for the people. And it's time to break up that ice, to get to work, and to get Wisconsin moving in the direction it was always meant to go, forward. Each and every one of you can make a difference in Wisconsin politics. As Annie said, your actions make a difference. Your actions will prevent racist redistricting and a total ban on abortions. We must inform Wisconsinites to vote for legislatures and justices who will uphold our right to vote for citizens at home and abroad. A little bit about Wisconsins abroad. We are Team Janet. Vote for Janet Protasewicz in the Supreme Court election. We are Team Jody. If you live in District 8, you have a legislative battle on your hands, and we want you to vote for Jody. We are also anti-censorship and pro-education. We are Wisconsin. And now to prove just how pro-education we are, we're going to take you back to school a little bit. I am proud and honored to introduce one of my first and very favorite professors, Howard Schweber. Professor Schweber joined the University of Wisconsin Political Science Department in the fall of 1999. He's got a PhD in government from Cornell and an MA in history from the University of Chicago. He spent 5 years practicing law in Seattle and San Francisco. And now Schweber teaches courses that focus on con law and legal and political theory. Professor Schweber has a history of working abroad and living abroad, just like us. From 2011 to 2013, he was a visiting professor and the first vice provost for the academic affairs at Nazarbayev University in Kazakhstan. He then served as special advisor to the president of NU from 2013 to 2018. In 2012, he was the Australian Fulbright Distinguished Chair in American Politics. He's been a guest lecturer at the Lahore Institute of Management Sciences, which is in Pakistan, and delivered invited lectures in Austria, Australia, Hungary, Kazakhstan, Jordan, and Israel. Professor Schweber is a regular guest on Wisconsin television and radio programs. He gives frequent interviews on the national, local, and international press scene. He's been a contributing blogger at HuffPo, operates his own blog, and guest blogs on other sites. He's a frequent public speaker, both on and off campus. And now you've read his works, you've listened to his interviews, but nothing can prepare you for the rapture. So pencils up, notebooks out, and welcome, Professor Schweber.
Hello, thank you for having me. I'm here to talk about the two most famous recent U.S. Supreme Court decisions, I think. The Dobbs decision that overruled Roe versus Wade, and the Bruen decision that altered the way we think about Second Amendment rights, both of which took place in the summer of, late spring of 2022. I want to go through those cases, those decisions, and explain why I think that they are, in fact, extremely radical in ways that go far beyond their implications for the specific issues that they discuss. And then at the end, I'll try to provide some broader context about courts, both nationally and in the state of Wisconsin, and issues that we as a nation and as voters face looking at courts going forward. So to begin with, right, it's always a big question when a major decision comes down. Is this just an alteration of existing doctrine, or is this really something revolutionary and new? In the constitutional literature, there's a lot of writing these days on the question of what exactly constitutes a constitutional revolution. That is, imagine not just a court decision, but an amendment, a textual amendment. At what point would an amendment or a change in practice or a court decision be a sufficiently radical change that we're really talking about a new constitutional order? And one example is the New Deal. When the New Deal was put in place and the executive branch of the government and the national government in general took on a whole new slew of responsibilities, expanded significantly, ought we to view that moment as a moment in which America entered into a new and different constitutional order, or ought we to view that as merely an adjustment to what was already practices that already existed? I'm not going to talk about the entire order of the U.S. Constitution, but on the question of rights, constitutionally protected rights, and specifically constitutionally protected rights that apply against states, that is, rights states are bound to respect, I want to argue that these two cases in 2022 do constitute, or at least if taken seriously, constitute a constitutional revolution. And one question is, how seriously are we to take them? How much farther do they reach than merely the issues that were before them? So again, the focus is not just on abortion and rights and gun rights, although those are, of course, two extraordinarily important issues, but more broadly on what the reasoning and the logic of these cases says about the court's thinking about rights in general going forward. Now, if you want to say something is a radical change, you have to establish some sort of baseline. What was it before? And I know that not everyone listening to this is a lawyer or a student of constitutionalism. So let me give a really, really brief background to how things looked from, let's say, the 1920s onward. Let's say the Civil War onward. Up to the Civil War, there were essentially no rights in the Constitution that applied against the states at all. None of the Bill of Rights applied against the states. The state of Wisconsin was perfectly free to punish people for exercising free speech, or to have an established religion, or to put people in jail without trial, or any other of those things that they wanted to do. The only restrictions that applied to states in the original U.S. Constitution were those found in Article 1, Section 10, that said there should be no titles of nobility, there should be no ex post facto laws, that's criminal laws that punish acts that were legal when they were committed, and there should be no impairment of the obligation of contracts. Now, that's not to say that states at that time were running around establishing religions and putting people in jail without trials, but they were constrained by their state constitutions, not by the U.S. Constitution. This is formally declared in a case in 1833 called Barron versus Baltimore, when the U.S. Supreme Court says none of the court's rights described in the Bill of Rights apply against the states. In 1868, we adopt the 14th Amendment, and for a very long time, nobody knows what it means. During the Reconstruction period, for the first couple of decades of the 14th Amendment, the Supreme Court's basic role was saying, this doesn't do anything. This does not create any substantive rights that states are required to respect. Starting in the 1880s or so, or 1870s and 80s, and then really picking up steam in the 1890s and early 1900s, the Supreme Court begins to find a series of rights contained in the 14th Amendment, and they actually take two distinct forms. First, something called substantive due process. So the 14th Amendment says that no one may be deprived of life, liberty, or property without due process of law. And in this era, the Supreme Court starts to find that that word liberty means that there are certain substantive rights that states may not infringe upon at all. Mostly, but not exclusively, economic rights. This is sometimes called the Lochner era, which is named for a famous case in 1905 that struck down a law in New York regulating working hours. The basic principle of this period was that the word liberty meant that states could not go beyond old, long-established police powers to regulate health and safety and regulate things like economic relations. And that this freedom from economic relations was contained in the Due Process Clause of the 14th Amendment. That's a long explanation, but the important thing is to recognize that in this period, starting in the 1890s, and then particularly as we get into the late 1890s, into the beginning of the 20th century, the Supreme Court began to recognize a range of substantive rights states were obliged to respect contained in the 14th Amendment, and that these were primarily, but not exclusively, economic rights. The other thing that happened was in 1925, for the very first time, the Supreme Court said that some rights in the Bill of Rights may also apply against the states. In the particular case, it was the freedom of speech. The Supreme Court said that freedom of speech applied against the states. This is called incorporation. What's interesting about this, well, there are a lot of things. One interesting thing about this is that it's not the case that the Supreme Court said, all the Bill of Rights now applies against the states. All states, please go and abide by these rights. Instead, it was not even amendment by amendment, it was clause by clause over a period of many decades that specific rights in the Bill of Rights were found to apply against the states. Most recently in 2022 or 2021, in the last year or two, forgive me for being imprecise, part of the Sixth Amendment for the first time was found to apply against the states. The Free Speech Clause was applied to the states in 1925. The Freedom of Religion Clause and the Establishment Clause weren't applied until the 1940s and weren't spelled out until the 1960s. And it's not until the Warren Court in the 1960s and 70s that you begin to see wholesale application of the Fourth, Fifth, and Sixth Amendments. These are the rights of criminal defendants and rights of suspects and rights of defendants at trial applied to the states. So the idea of the possibility that some rights in the Bill of Rights might apply against the states goes back to 1925. The actual application of those rights is stretched out over most of a century that follows. And between 1925 and the 1940s, there's no further progress. So it's not until really after World War II that we see the idea of incorporation used to apply a range of rights against states. So at least since the 1920s, and really since before that, we have two distinct ways of finding rights that states have to respect. One is application of the Bill of Rights. This is called incorporation. That is, the Bill of Rights used to apply only against the federal government. Because of the 14th Amendment, we say they are now incorporated, meaning the states have to respect them as well. Two, this thing called substantive due process, the idea that there are liberties states may not infringe upon. Now, as I mentioned, initially, substantive due process is all about protecting economic rights and striking down laws that regulated the economy. That ended very abruptly in 1937 and 1938 when the court's pattern of striking down laws that were part of the New Deal created a political crisis. FDR was elected, was able to appoint some new justices. At least one or two justices changed their minds, and that practice of finding strong protections of economic rights fell by the wayside. But before that happened, and going back again to 1925, there were a couple of cases in which the Supreme Court recognized a whole different category of substantive due process rights that did not have to do with economic behavior. These are rights of parents. Specifically, there was an attempt by a state to ban all schooling in languages other than English. This was struck down on the grounds that the concept of liberty includes parents' liberty to decide how their children should be educated. There was a second case in which a state tried to ban all private schools, including religious private schools. That was challenged and struck down. Interestingly, in that discussion, the parties made a whole slew of arguments. They argued about religious liberty and the property interests that the operators of the schools had in their business, but the court didn't take up any of those limitations. They didn't incorporate the religion clauses of the First Amendment, for example, and say, yes, these apply against the states now. Nor did they find that freedom of religion is part of, except in commentary, but as part of, they didn't rule that any particular freedom to exercise religion is part of substantive due process. What they relied on instead was that first case about parents' rights and said, nope, this is part of parents' rights. So in the 1920s, although there's discussion of the possibility that substantive due process might cover a whole range of different kinds of liberty, freedom to travel, freedom to choose one's occupation, freedom of religion, freedom of lots of other things, in practice, the only two clear categories that are defined under substantive due process are the freedom of parents to have some degree of control over the upbringing of their children, and economic freedom, the freedom to make contracts without restriction by regulation. As I said, that economic freedom ends after 1938, but the thread that says there's something in the due process clause of the 14th Amendment that protects the integrity of family life, that remains, and that will become the right to privacy. So after the late 1930s, we have clearly established two sources of rights that states have to respect. Incorporation, the amendments to the first 8 amendments of the Bill of Rights. And remember, they're not incorporated all at once. In fact, to this day, they're not all incorporated. It is a piecemeal process whereby individual rights mentioned in the Bill of Rights are found to apply against the states. And separately, substantive due process. All right, if we flash forward now, throughout the 60s and 70s, as I think I've already mentioned, a large number of the rights in the Bill of Rights are incorporated and said to apply against the states. For example, the right to counsel at trial, that sort of thing. Roe versus Wade, which is one of our main focuses today, is an expression of that other source of rights, that substantive due process theory of rights. And that too has a history, a modern history. After 1938, after the end of that era where substantive due process was used to strike down economic regulations on a regular basis, there wasn't a lot of appetite to revisit that theory for a while. But it did come back. And by the 1960s, the idea that there's a privacy or a secured area of life, starting with parents' authority over their children, that should be shielded against state intervention, becomes a full-fledged idea of a right to privacy. So in Griswold versus Connecticut, we are told that there's this right to privacy that encompasses the use of contraception. By married couples, there's another case called Eisenstadt versus Baird that says it also applies to single people. And in Roe, this becomes the source of the right to abortion. And it's very, very important to recognize that Roe versus Wade did not say women have a right to choose an abortion. What Roe versus Wade said was that women have a right of privacy that is broad enough to include the decision to terminate a pregnancy. That's an important point. The Roe court was not picking out abortion as a specific activity and saying this is a protected right. They were looking at abortion as a specific activity and said this falls in the category of activities that is protected by this theory of substantive due process. There isn't really any argument that a right to choose an abortion or a right to raise one's children as one sees fit or a right to send children to schools of one choice, there isn't really a theory that any of those kinds of rights exist in the Bill of Rights or specified anywhere in the Bill of Rights. They exist as this expression of this idea of liberty in the Due Process Clause under the rubric of substantive due process. That's the model that is in place from at least the late 1930s, I'm going to argue, until 2022. And that model has some specific features. First, although there are these two very distinct sources of rights, the two kinds of rights are treated essentially in the same way. This isn't actually quite fair. In fact, one of the striking things about Roe versus Wade is how weak a protection for the right to choose an abortion it provides, far weaker than the protections provided for other rights recognized in the same era. Think about free speech, for example. But in general, all claims of rights are tested under what are called tiers of scrutiny. The idea is simple. The details can get complicated, but the idea is very simple. Think about procedures for a minute. We don't use the same procedures for parking ticket cases that we use for capital cases that can result in the death penalty. There's a very good reason for that. If we insisted that every parking ticket can be contested with the provision of a lawyer at no cost to the defendant, appeals perhaps up to the U.S. Supreme Court, writs of habeas corpus that allow people to go to court and have their sentence tested in special ways. If we applied all of that apparatus and all of those mechanisms to every parking ticket, the system would become utterly unworkable. Conversely, if we treated murder trials like parking ticket hearings, they last 10 minutes in front of a judge and there's no need for any particular procedures, that would be intolerable. So when you think about procedures, it becomes really obvious that, of course, not all government actions trigger the same kind of procedural requirements, and they couldn't. Well, the same kind of idea that there are differences in degree of how serious something is, of how strong a protection it requires under the Constitution, that same idea applies to rights and laws as well. And again, it's easy to think of an example: speed limits. No one thinks that the 55-mile-an-hour speed limit on a particular road, let's say the Beltline, the highway in Madison, Wisconsin, is exactly the precisely safe speed. That driving 56 is dangerous and driving 54 is perfectly safe, regardless of any conditions or who the driver is or what vehicle they're driving. Obviously, a 55-mile-an-hour speed limit, or any speed limit, is to some degree arbitrary. The same goes for an age restriction. Why should the age restriction on drinking be 21 rather than 22 or 20? It's a law. It's a date. It is an age that was chosen. And those kinds of decisions are treated as generally acceptable. That is, unless a law strikes at a fundamental right or singles out a vulnerable class like a racial minority, courts will accept the law so long as it has what's called some rational basis. As long as the speed limit is not crazy, without any justification whatsoever, then courts are not going to second-guess the legislature on their decision that 55 is a good speed to drive on, or is a good number for the fastest speed one is allowed to drive on the Beltline. And courts are not going to second-guess legislatures on the idea that 21 rather than 20 or 22 is the appropriate age for buying liquor. Things get different when you have fundamental rights at stake. And I want to be very clear here. From at least the late 1930s or the early 1940s, right up to 2022, there was no difference, at least formally. You can point to individual cases that were handled in different ways, but formally there was no difference in the way rights that existed as a matter of substantive due process and rights that were incorporated from the Bill of Rights were tested, or rather laws infringing on those rights. If the complaint was that a law infringed on a fundamental right, whether it came from the Bill of Rights or was part of liberty in the Due Process Clause, courts would apply what was called strict scrutiny, which means the government needed a really, really strong justification for the action that was taken. Now, both of these things, the low level of rational basis scrutiny that gets applied to speed limits and age requirements, and the very high level of review called strict scrutiny, which gets applied to, let's say, restrictions on freedom of speech or classifications that disadvantage racial minority groups. Both of these approaches are two-part approaches. They have a means and an ends test. They ask, what's the purpose the government is pursuing? And what means is the government using to pursue it? So if you want to have a law that restricts a freedom, the right to free speech, let's say, that law is unconstitutional unless the government can show it is pursuing a compelling state interest. That's the ends part of the test. And there's no way to pursue that, to achieve that goal that infringes less on free speech rights. That's the means part. It must be what's called narrowly tailored, the least restrictive possible means, a means that infringes on the right in question to the least possible degree. And even then, it's only justified if there's a compelling interest being pursued. These are not precise terms, but you can see by the vocabulary that when this particular test is applied, most of the time laws are going to fail. Conversely, if you're talking about speed limits or age requirements, and you're using this rational basis test, then you ask, is there a legitimate purpose? And after all, there's an enormous range of legitimate purposes governments may pursue. And you ask, are the means chosen rationally related to that purpose? It's a little hard to think, in fact, of a non-rational speed limit. One that has no basis in any kind of possible set of rational facts that anyone could rationally believe. I like to use the example of a speed limit that operates differently depending on the sign of the zodiac under which a driver was born. Unfortunately, it's come to my attention that there's a fair number of people who think that that's a perfectly rational basis for having differential speed limits, so maybe even that example doesn't work. So the point is, when we apply this rational basis scrutiny, when we're testing speed limits and age requirements, almost always the laws will be fine because we don't think there's a really major concern at issue, even though it is true that restricting how fast people drive on the roads or restricting when you can drive by alcohol based on age is in some way a restriction on your freedom. Conversely, when a fundamental right is at stake, or when a discrete insular minority, that's the phrase, is being targeted, then we apply this much, much higher level of scrutiny, strict scrutiny, and most laws will fail. So you have this graded set of standards, and over time you get all kinds of standards in the middle, intermediate scrutiny and intermediate scrutiny plus. And the court develops a whole range of versions, but it's always the same ends means approach. What's the purpose that the state is trying to pursue? What are the means that it's using to pursue it? And the question is, how high a bar will we put for accepting their purpose, and how strict a bar will we apply for deciding whether the means they're choosing are legitimate to achieve that purpose? And that's the basic model of rights litigation, of rights adjudication, up until 2022. So a quick review. After, in the 1920s, and starting in the 1890s and then through the 1920s, we see the development of two distinct sources of rights. Incorporation, that's the application of the Bill of Rights to the states, which is done one right at a time, it's not wholesale. And substantive due process, the idea that there are rights not listed in the Bill of Rights that are nonetheless protected by the Constitution because of the adoption of the 14th Amendment's Due Process Clause. After 1938-37, economic rights drop out of that substantive due process category. And the court says, no, economic regulations are generally fine. And in fact, it's in that context that they coined this phrase, rational basis. If these economic, the case is called Caroline Products, United States versus Caroline Products in 1938. The court says, if an economic regulation has a rational basis, we're not going to second guess the legislature and question the legitimacy of that regulation. Those laws are presumptively constitutional. But it remains the case that where other kinds of rights are at issue, substantive due process claims can trigger higher levels of scrutiny, and so can incorporated rights claims. And so after the late 1930s, going forward, this becomes the model. From 1938 to 2022, whether a right is asserted based on incorporation from the Bill of Rights or as part of substantive due process, if the court determines that a right is at issue, a constitutional right is at issue, they will apply strict scrutiny. They will demand that there be a compelling end, a compelling purpose. And if the purpose is anything less than compelling, the law is unconstitutional. Even if the purpose is compelling, they'll demand that the means that have been chosen are the most narrowly tailored possible, that infringe on the liberty of the individual as little as possible to achieve that purpose. And if that's not the case, then the law will be unconstitutional. And that's strict scrutiny. Conversely, where rights are not an issue, we have the rational basis scrutiny that emerged in the late 1930s in the context of economic regulation. Pardon me. I was a little embarrassed by that curled up collar. So why is Dobbs and why is Bruen a radical change from this general model? Well, to understand that, we have to dig a little bit more into the way rights were treated starting in the 1990s. Forgive me if I leaf through some documents. So I want to talk about a case in 1997 called Washington versus Glucksberg. You might remember this case. It was testing a Washington state law that prohibited physician-assisted suicide. And the claim was that substantive due process, the kind of privacy-based rights or rights to control one's family or rights to control, and if you think about the public-private divide as a fundamental element of liberal democratic ideas, then substantive due process is the idea that the government is intruding into the wrong side of the public-private divide, into places where it has no business going because we do not accept the idea of a totalitarian state. In Washington versus Glucksberg, the claim was the state is intruding into an area it has no business being, interfering with people's desire to have a physician help them end their own lives. The Supreme Court rejected that argument. And the reasoning by which they rejected that argument is very, very important. So let me go back to Roe versus Wade in 1973 again for a minute. The case is written by Harry Blackmun. And as I mentioned before, Blackmun doesn't say the Constitution guarantees a right to abortion. Blackmun says the Constitution guarantees a right to privacy, which is broad enough to include a woman's choice to have an abortion. By situating the specific right claim, abortion, into the larger context, a right to privacy generally, Blackmun can use a certain kind of set of arguments to explain the outcome. In Washington versus Glucksberg, Rehnquist does the opposite. He says this is a right about physician-assisted suicide only. The question is not, is there a right to privacy broad enough to include physician-assisted suicide? The question is only, is there a right to physician-assisted suicide? And Rehnquist says that in answering this question, we must look to history. That is, we must ask whether the idea of a right, of this specifically described right, a right to physician-assisted suicide, is deeply rooted in our history and tradition. Now, if you ask, is a right to control your own medical treatment deeply rooted in our history and tradition? The answer is almost certainly yes. That's the broad framing of the question, just like the right to privacy in Roe. But if you ask, is physician-assisted suicide specifically conceived of as a constitutionally protected right, is that idea deeply rooted in our history and tradition? The answer is no. And that's exactly the answer that the Supreme Court reached in Rehnquist's opinion. So Washington versus Glucksberg takes a very, very different approach from the approach taken in Roe versus Wade. In Roe versus Wade, the Supreme Court looked at the specific right at issue, abortion, and analyzed it in terms of the broader right of which it is a part, the right to privacy. In Washington versus Glucksberg, we get this principle of specificity. You have to define the right at issue as specifically as possible, and the right should only be found to be protected if described in that specific way. It is as a constitutional right, it is found to be deeply rooted in our history and tradition. This was controversial. In particular, Justice Kennedy in cases like Lawrence versus Texas, striking out anti-sodomy laws, and Obergefell versus Hodges, the case recognizing same-sex marriage, deliberately, specifically took issue with this approach. Here's what he said. So this is in Obergefell versus Hodges, and this is Kennedy responding to people who opposed the idea that the Constitution secures a right to same-sex marriage. And what Kennedy said was, the respondents refer to Washington versus Glucksberg, that's the assisted suicide case I just mentioned, which called for a careful description of fundamental rights. That's that principle of specificity. It says the right at issue has to be described as narrowly as possible and then be tested. They assert the petitioners do not seek to exercise the right to marry, that's the broad framing, but rather a new and non-existent right to same-sex marriage. That would be the narrow framing. You can see how much work framing does here. if you accept the idea, which many people do not, but the Supreme Court does, if you accept the idea that one of the tests for finding a substantive due process right is this right deeply rooted in our history and tradition, then to answer that question, it's going to make all the difference in the world if you describe the right at issue narrowly or broadly. If you ask in terms of same-sex marriage, is the right to marry the person of your choice deeply rooted in our history and traditions? The answer is absolutely yes. If you ask, is the right to marry a person of the same sex conceived as a right deeply rooted in our history and traditions, then the answer is no. In Glucksberg, Washington versus Glucksberg, Rehnquist used the narrow framing of the right as physician-assisted suicide to find that that right was not rooted in our history and traditions. In Obergefell, Kennedy did the opposite. He said this is about the broad right, the right to marry, and that right is deeply rooted in our traditions. So going back to the argument he was having, they assert the petitioners do not seek to exercise the right to marry, but rather a new and non-existent right to same-sex marriage. While that approach may have been appropriate for the asserted right there involved, physician-assisted suicide, it is inconsistent with the approach this court has used in discussing other fundamental rights, including marriage and intimacy. Loving versus West Virginia did not ask about a right to interracial marriage. So Loving versus West Virginia was a case from back in 1965 that struck down anti-miscegenation laws banning marriage between people of different races. In reaching that decision, the Warren Court did not say we have a long-standing, deeply rooted historical tradition of a right to marry people of a different race. They said we have a long-standing, deeply rooted historical tradition of being allowed to marry whomever you want, and these laws interfere with that right. Remember that family, marriage, privacy goes all the way back to 1925 and the rights of parents over their children as the very basis, the very first understanding of the idea that the 14th Amendment protects substantive liberties that the states are required to respect. So Kennedy in Obergefell is drawing a connection back to that very, very early version of substantive due process. Remember also that I mentioned that during that early period of substantive due process, there was a case called Lochner, which became famous as an example of judicial overreach because the court was striking down economic regulations. In his dissenting opinion in Obergefell, Roberts cites Lochner by name 16 times. That is, he says, this is going back to that kind of judicial overreach. So at the time of Obergefell, the split between justices who want to follow Rehnquist's approach in Washington versus Glucksberg, justices including Roberts, that says we define rights very, very narrowly. We don't protect rights that are not deeply rooted in our history and tradition. We don't, as a court, seek to find new rights that were not previously recognized. The contrast between the justices who took that approach, which we speak of as conservative, and justices like Kennedy, who wanted to frame rights broadly, or justices like Blackmun and Roe, for example, who wanted to frame rights questions broadly so that new specific rights claims could be brought within the ambit of long recognized categories. That split had become fundamental. And now we get to Dobbs. So Dobbs versus Jackson Women's Health Center is the case, of course, in which Alito writes an opinion overruling Roe versus Wade, describing it as egregiously wrong at the time it was decided. As I said at the very beginning, overruling Roe versus Wade is not the most radical thing about the Dobbs opinion. The most radical thing about the Dobbs opinion is the way it completely changes our approach to thinking about, it completely sides with one side of the debate that I just described and completely does away with the other. So Alito says, for example, the Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. That is to say, this is not an incorporated right. This is not a right that comes from a clause in the Bill of Rights. So the question is this a substantive due process right? As Alito puts it, one in the due process clause of the First Amendment. Here's what Alito has to say about those rights. In deciding whether a right falls into either of these categories. Now, I'm sorry, I skipped a sentence. Alito makes the point that I've been making repeatedly, that there are two categories of rights, those that are incorporated and those that are found in substantive due process. Our decisions have held that the Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the First Eighth Amendment, The second category comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. And then he says, in deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition. And he speaks of another test called essential to order liberty. So he talks about Washington versus Glucksberg and the way, in that case, Rehnquist described the right very, very specifically and looked to historical tradition. And he says, historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause. The emphasis on new is important. Alito is using that principle of specificity to describe an approach that makes it very difficult, if not impossible, to find any new rights contained under the broadly defined rubric of rights that have long been recognized. Speaking of Roe, he points out that the kind of privacy right at issue in Roe is the right to make important personal decisions without governmental interference. And he says, the kind of cases that have been raised in this context, like parents raising their children or using contraception, all have to do with procreation and families, but, quote, none of these decisions involve what is distinctive about abortion, its effect on what Roe termed potential life. So another principle has emerged. The first principle was we're going to apply an historical analysis of very specifically defined rights and ask whether they are deeply rooted in our history and tradition. And now there's the second principle that says when a certain kind of question is at stake, the distinctive question of potential life, that will change our analysis. The explanation for that is unclear, although he will try and give it some description. And here's what he says. Why does that make a difference? For example, the government responds on Lawrence versus Texas and Obergefell versus Hodges to say that new rights may be discovered. This Alito rejects outright. So I'm sorry, I've confused the issue. In going forward in the discussion, Alito is first going to explain why Lawrence and Obergefell cannot be explained based on describing rights generally. In other words, he's going to reaffirm the idea that rights must be defined specifically before they can be protected by the Constitution. And his reasoning is that otherwise there'd be a slippery slope. Here's what he says. Respondents and Solicitor General rely on cases like Lawrence versus Texas, right to engage in private consensual sexual acts, and Obergefell versus Hodges, right to marry a person of the same sex. These attempts to justify abortion through appeals to a broader right to autonomy to define one's concept of existence prove too much. Right? So the Roe approach of finding abortion as part of a broader right of privacy is wrong-headed. Why? These criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. It would be a slippery slope, he says, if we defined a right of privacy broadly to justifying as protected rights all sorts of undesirable conduct. What's slightly amusing about this is that he's quoting here, and he's quoting from one of the lower court opinions in Washington versus Glucksberg. That is, he's making a signal that he's explicitly reviving the theory of right specificity that was developed in Washington versus Glucksberg and applying it to the issue of abortion, precisely the move that the Roe court did not do. So that's the specificity point. On the point of potential life, he says, none of the other decisions cited by Roe and Casey involve the critical moral questions posed by abortion. So here's our two-part argument, or our two-part analysis of Roe. One, Roe was erroneous because the court relied on a general description of the right at issue rather than a very specific one, and did not ask whether a constitutional right, recognition of a constitutional right to this specific act is deeply rooted in our history and tradition. And two, the court did not consider the fact that this case, unlike all the others apparently, involves a profound moral question. I need to be clear about that first point about specificity. A lot of commentators have tried to say abortion was legal or was tolerated throughout our history. That may be true, but that is not the test that Alito is talking about. The test Alito is talking about asks, is it the case that abortion was recognized as a constitutionally protected right throughout our history? And if you frame the question that way, with that degree of specificity, then the answer is quite clearly no. And that is the end. I mean, those are only a couple of quotations, obviously, but that's the analysis of Alito's majority opinion. Now, one obvious question this leaves open is, what does this ruling do to cases like Lawrence and Obergefell? After all, people who oppose those decisions, people who oppose the idea of a constitutional right to same-sex marriage, will claim that this is a profound moral issue, right? I mean, those people will have no trouble saying that just like the issue of potential life, the issue of same-sex marriage is profoundly morally important. And these people will have no trouble making an argument that says there's no specific right of same-sex marriage recognized in our history as a, that is deeply rooted in our history and traditions as a constitutionally protected right. So at a bare minimum, Alito is inviting, I read this as a public invitation to litigants, lawyers, and parties to bring cases challenging Lawrence and Obergefell under this same logic, and he's given them the exact roadmap they have to follow to make the argument. Argue that this is an issue that involves a profound moral question, argue that the right needs to be described with absolute specificity, and argue that this specifically described right as a constitutional right is not deeply rooted in our history and traditions, and that would give the Roberts Court everything it needs to strike down those cases as well. Thomas concurs. Thomas simply wants to overrule all substantive due process cases, including those protecting contraception and the rights of parents. Thomas's actual reasoning takes us all the way back to the 1870s. He thinks the due process clause is the wrong place to look, and that we should go back to an earlier argument that occurred shortly after the adoption of the 14th Amendment and start over. I will leave that argument aside. I will say historically, his argument is quite plausible. You have to go back to a series of cases called the Slaughterhouse cases, and a case called Cruikshank, and a few others just after the Civil War. He is not wrong to say that the Supreme Court at that time found that a different part of the 14th Amendment, the Privileges and Immunities Clause, did not guarantee any substantive rights. And he's not wrong to say that that was a very, very dubious conclusion. And he's not wrong to say there are good reasons to think that it was wrong and should be revisited. What's troubling about his approach is that it involves simply abandoning 150 years of rights legislation, of rights jurisprudence, and starting over. And no one really wants to do that. Nonetheless, Thomas makes the point that the argument that Alito relies on can be used, as I've tried to show a moment ago, to challenge a whole slew of substantive due process rights, including some that we've taken, that with respect to which we've taken their legitimacy for granted for a long time. Kavanaugh tries to be reassuring. He's speaking of Eisenstadt versus Baird, that's contraception, Loving versus Virginia, that's interracial marriage, and Obergefell versus Hodges, that's same-sex marriage. I emphasize that overruling Roe does not mean the overruling of these precedents. It does not threaten or cast doubt on those precedents. The problem is it's not at all clear why. As I've tried to suggest, if we adopt Alito's sort of updated version of the principles of specificity and deep historical rootedness, it's very difficult for me, at least, to see why cases like Obergefell or Loving versus Virginia or Eisenstadt versus Baird, why any of those principles survive this new kind of approach to scrutinizing substantive due process rights. Dobbs, taken alone, would be somewhat radical. Certainly overruling a precedent as long-standing as Roe versus Wade is a radical move. Certainly the logic and reasoning that Alito employs has potential radical consequences, as I've tried to demonstrate. Certainly the approach Alito employs is a radical departure from the approach that's been used for the last nearly 100 years of thinking about these kinds of rights claims. But that is not the extent of the constitutional revolution. To see that, we have to turn to Bruen, which is even more radical. And it's when we look at Bruen and Dobbs together that we see the shape of a revolution that may have just occurred. Bruen is written by Thomas. You'll recall a moment ago, I pointed out that Thomas is quite eager to wipe out the entirety of substantive due process rights and start over. Bruen is not about a substantive due process right. It's about an incorporated right. It's about the Second Amendment and gun rights. Now, I want to backtrack a minute. I said that since the late 1930s, we've recognized two sources of rights, incorporated rights and substantive due process rights. I've said that for all of these rights, we have this tiers of scrutiny approach. That is, where if it's speed limits or trivial classifications that we don't care too much about, we apply rational basis scrutiny. We ask, is the end legitimate and the means rationally related to that end? If a fundamental right is at stake, or if there's a really serious equal protection concern, then we apply strict scrutiny. We act We ask, is the end compelling? Are the means narrowly tailored to achieve that end? And that's the highest level of scrutiny that we have. During World War II, that level of scrutiny was applied and was found that the internment of hundreds of thousands of people of Japanese descent could be justified. Thomas in Bruen is going to abandon that entire approach. The 100-year approach of using means-ends tests and tiers of scrutiny and applying them equally to all kinds of constitutional rights claims, all of that is out the window after Bruen. Here's what he said. He talks first about two earlier cases, Heller and MacDonald, which were the cases that recognized an individual right to bear arms under the Second Amendment in the first place. If you're curious, Heller was the case that recognized that right with respect to the federal government. MacDonald is the case that recognized that that right had been incorporated, that is, applied against the states. Prior to MacDonald versus City of Chicago, that was not true. And this is in the 2000s. This is a recent bit of history. In those cases, we held that the Second and 14th Amendments, right, you have to name both of them, because the Second Amendment is incorporated by the 14th Amendment, protect an individual right to keep and bear arms for self-defense. In the years since then, the courts of appeals have coalesced around a two-step framework for analyzing the Second Amendment challenges. Today, we decline to adopt that two-step approach. Okay, what's the two-step approach? It's this approach I've been describing all along. Is there a right? And if there is, what we apply the appropriate level of scrutiny? Instead, here's the new test. We hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not posit the regulate posits an important interest. Rather, and here's the new test, the government must demonstrate that the regulation is consistent with its nation's historic tradition of firearm regulation. So in Dobbs, we were told that there's no substantive due process right unless there's a deeply rooted historical tradition of recognizing that right as constitutionally protected based on a specific description of the right asserted. In Bruen, we're told that in the case of the Second Amendment, there is always a protected right unless you can show that the regulation that is being proposed is deeply rooted, as specifically described, is deeply rooted in our nation's history and tradition. You have to stop for a minute and consider how different those two approaches are. One puts the burden of presumption on the side of saying that there is no right. One puts the burden of presumption on the side of saying there's not only is there a right, there's no legitimate regulation. It becomes much, much harder to assert a new form of an existing substantive due process right. Conversely, it becomes much, much easier to assert a new form of a Second Amendment right. Now, the logic of this has to do with something very close to natural law theory. That is, Thomas is saying the rights under the Second Amendment are not created by the Second Amendment. They were always there in some kind of background understanding that predates the Constitution. It has always been widely understood that the Second Amendment codified a pre-existing right. The amendment was not intended to lay down a novel principle, but codified a right inherited from our English ancestors. So now Thomas is arguing that the right in question goes back to the 1600s, which implies that the form of regulation in question perhaps needs to go back to the 1600s in order for it to be legitimate. Heller and MacDonald expressly rejected the application of any judge-empowering interest-balancing inquiry. That's that tiers of scrutiny means and ends test that we were talking about. That is now rejected. That asks whether the statute burdens a protected interest in a way that is out of proportion to the statute's salutary effects. Right? The whole idea was, is there a compelling interest? Is this a narrowly tailored measure to achieve that interest? That's a balancing. That's an analysis of proportionality. Is the means proportional, indeed, as narrowly tailored as possible to achieve the goal? We're abandoning that test, says Thomas. Instead, we're going to ask, one, as specifically framed, just like the right in Dobbs, the regulations in Bruen must be described with specificity. Is this specific regulation one that is too deeply rooted in our historical practice as a regulatory practice? In some cases, he says that inquiry will be fairly straightforward. For example, when a challenge regulation addresses a general societal problem, the lack of distinctly similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. That is, if public safety is a long recognized problem, and We've not seen laws of the particular kind that we're seeing now in our historical tradition. That shows that this is not a constitutional approach to that problem. The problem existed. The fact that this particular kind of regulation was not, the fact that it is new, the fact that this is a kind of regulation that is not deeply rooted in our history is by itself grounds to say that it must be unconstitutional. Anything new is unconstitutional. Likewise, if earlier generations addressed the societal problems but did so through materially different means, that also could be evidence that a modern regulation is unconstitutional. A regulation today that is different from the regulations that were adopted in an earlier period is also unconstitutional. Now, Thomas wants to insist that there are some ways which we can recognize change. For example, weapons. The Second Amendment does not only protect the kind of weapons that existed in 1791, it protects assault rifles. On that side of the equation, change and modernity and newness are fine. But we've already recognized its reference to arms does not apply only to those arms existing in the 18th century. Like all analogical reasoning, determining whether a historical regulation is a proper analog for distinctively modern firearm regulations requires a determination of whether the two regulations are relevantly similar. So where you're talking about types of guns, we are not bound by historical practice. But when you're talking about regulations of those guns, we are. What does that mean? Well, for example, that means you cannot say that the individual right to bear arms does not include assault rifles, but you can say, as federal courts have said, in fact, following this case, laws banning silencers or laws against filing off serial numbers are unconstitutional because there were not laws of that type in 1791. Again, this can get tricky, so let's walk through it carefully. In Dobbs, we were told no rights that are not recognized, going back at least to 1868, the adoption of the 14th Amendment, can be recognized under the Substantive Due Process Clause. Now we're being told, as a matter of substantive due process, now we're being told that where an incorporated right is involved, no regulation that doesn't go back historically is permissible. The right is defined broadly to exclude any regulations that are not specifically the same as regulations that occurred earlier, except that where types of weapons are occurred, where the right is occurred. So the regulations, but where the right is occurred, that is infinitely expansive. Secondly, we can recognize new kinds of sensitive places. There are long-standing laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. And Thomas is perfectly willing to accept there are new kinds of sensitive places. Courts can use analogies to those historical regulations of sensitive places to determine that modern regulations prohibiting the carry of firearms in new and analogously sensitive places are constitutionally permissible. So the one place, or the two places where novelty is permitted is one, in broadening the right to bear arms to include types of arms that had no analog in our historical practices, and two, to recognize sensitive places like public hospitals, perhaps, that didn't exist at the time. But the requirement of historical groundedness for the regulation will be applied in this very narrow and very specific way. The burden falls on respondent to show New York's proper cause requirement is consistent with its nature's historical tradition of firearm regulation. Only if respondents carry the burden can they show the pre-existing right codified in the Second Amendment and made applicable to the states with the 14th does not protect petitioner's proposed course of conduct. It's sort of a double negative. You have to prove that it is not the case, that the right that is not the one mentioned in the Second Amendment, but the one defined in the Second Amendment, but the one that already existed that is recognized by the Second Amendment. So the right itself has to be defined in terms of historical practices. Does not prevent regulation of the type you're proposing, and the test is, were there essentially identical regulations at the time at the relevant historical time? I'm stumbling over relevant historical time because of one of the other things that Thomas says in this opinion. The 14th Amendment arrives in 1868. That's the amendment that says, well, starting in 1925, it says, rights in the Bill of Rights may apply to the states. But when Thomas is looking for historical precedents of regulation, he's not looking to 1868, he's looking to 1791. As he says, we have generally assumed that the scope of the protection applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. This is in fact completely false. That has not been a general understanding. But he is arguing that if a right is incorporated by the 14th Amendment, even though that incorporation wasn't recognized until 1925 or 1940s or the 1960s or 2 years ago, the definition of the right refers back to the Constitution at the time the Bill of Rights was adopted in 1791, and therefore it is only regulations that were in place in 1791 that are, and only regulations that are as specifically described that were in place in 1791 that can be applied today to firearms, including firearms that didn't exist at that time. Now, that's obviously radical in a couple of ways. It's radical in the way it changes our treatment of the Second Amendment. This is a long discussion, but I'll ask you to take my word for it. It's completely different from any Second Amendment jurisprudence before. But what's much more radical is there's absolutely no reason in this logic to restrict the argument to the Second Amendment. If this is a general argument about incorporated rights, that the fact that a right is written in the text makes a law that infringes on it presumptively unconstitutional, that the test for constitutionality is the existence of a specific analog statute in 1791, there's absolutely no reason why that same logic shouldn't apply to, let's say, the First Amendment or the Fourth Amendment. Taken seriously, the reasoning in Dobbs is not limited to abortion. It expands to any substantive due process right. And taken seriously, the reasoning in Bruen is not restricted to the Second Amendment and guns. It applies to any incorporated rights. Taken seriously, these two decisions would wipe out 50 years at least of constitutional rights jurisprudence, impose dramatic new restrictions on the ability of legislatures to pass laws across an enormous range of areas, completely redefine our understanding of the Free Speech Clause, the Free Exercise Clause, and the Establishment Clause, among many others, let alone the rights of criminal defendants or government regulatory authority, and completely undermine the analytical framework that is defined, the means, ends, tests of the tiers of scrutiny, and the two different categories of rights being treated the same. All of that is completely undermined by this new approach that says there's an absolutely different approach, absolutely different way of analyzing substantive due process rights from analyzing incorporated rights, and that in the one case, there's a very powerful presumption that no right will be found. In another case, there's a very powerful presumption that no regulation can be justified. And I can't say this strongly enough, absolutely nothing that I can see in the reasoning of either of these cases restricts their operation to specific issues of abortion and guns. And that's why I suggest that these cases are, in fact, a moment of revolutionary change if they are carried forward. It's not clear whether they will be. I have not yet seen cases applying Dobbs to issues other than abortion. I have not yet seen cases applying Bruen to issues other than guns. I think very strongly that both opinions are written as invitations to litigants who are of a mind to do so, to bring those claims and challenge same-sex marriage and interracial marriage, and challenge a whole slew of regulations and rights assertions that have emerged over the course of the 20th and early 21st century. I think is an invitation to precisely launch that kind of revolutionary reshaping of our entire constitutional understanding at the moment that revolution is confined to abortion and guns. And the question is, of course, will it stay there? It's also, now, as I mentioned at the outset, I'd like to make a few comments about the larger significance of these phenomena. I've been talking for a good while, so I'll just take a couple more minutes. This is an approach to judicial decision-making that puts the court, and what is true of the U.S. Supreme Court is now true of the Wisconsin State Supreme Court. That is, if Roe versus Wade is overruled, then the question of abortion rights goes to the states and the state constitutions. Remember at the very beginning, I said that although the 14th Amendment rights didn't apply against the states, until well after the Civil War, states had state constitutions. And they had rights, people had rights under those constitutions. In fact, in some cases, state constitutions provide broader rights than does the U.S. Constitution. A number of states, I think it's 12, but please don't quote me, have state constitutional guaranteed rights to education, for which there is no right under the U.S. Constitution. A lot of state constitutions secure a right to vote, which the U.S. Constitution does not do. The U.S. Constitution says you cannot be denied the right to vote on the basis of your race or on the basis of being of age if you're over 18, but other than that, there's no right to vote no general right to vote guaranteed at all. This often shocks many Americans. So as I was saying, a lot of these issues now turn to the states, and a lot of conservative-dominated state Supreme Courts are taking it upon themselves to follow the lead of this extremely radical conservative-dominated U.S. Supreme Court and craft really dramatic and radical new ways of thinking about rights claims that don't just sharply alter the outcome of the particular issue, but alter the way these courts will think about all rights claims, at least potentially, all rights claims for a generation to come. That's one of the reasons that the forthcoming Wisconsin judicial election is so incredibly important. It's one of the reasons that the fact that for more than 30 years, political conservatives have made active efforts to gain control of the courts, and political liberals have largely ignored that issue, essentially taking the courts for granted, has been such a suicidally bad strategy if your concern is to promote liberal democratic ideals and progressive policies. It doesn't have that does not have to be your concern. I'm just trying to point out that there's an imbalance in the priority that was laid to focusing on courts, and because of that, the outcome has been a development in courts that is very strongly, effectively politically partisan. I'm very reluctant to describe judges in courts as conservative or liberal, not because there are not very distinctive judicial philosophies, but because they map very poorly onto the straightforward policy questions that distinguish political conservatives and political liberals in our ordinary discourse. The debate between Kennedy and Rehnquist over whether rights should be framed in narrowly specific terms or very broad terms when testing the degree of their historical rootedness, that's a debate between a judicial liberal and a judicial conservative. It's not quite the same thing, as you can see, I think, as policy liberalism and policy conservatism. With what this Supreme Court is doing, however, that distinction is breaking down. This is a form of judicial conservatism that is tailored to favor politically conservative outcomes. So yet another risk, yet another potential consequence of these developments that I'm describing is the increased politicization of the court and the increased stakes for political and policy matters of judicial elections like the one coming up in Wisconsin. That's rather a lot to think about, and I've been talking for a full hour, so I'll stop now. I hope that you found this interesting and informative. I hope that it adds a dimension to your thinking about our national politics and especially our judicial politics going forward. And the sponsors of this event can give you my email address, and I'm very happy to answer questions or hear complaints about this presentation in the future if you want to reach out and get more information. Thank you very much for your time, and I appreciate you letting me talk to you today.
Professor Schweber, it was an honor to have you, and we hope to hear from you again soon. For questions and comments, please note that his email is listed on the slide, howard.schweber@wisc.edu. I'd like to thank Bruce Murray in the Progressive Caucus, Ann Hesse in the Women's Caucus, State Teams Coordinators Jennifer Von Estorff and Carol Moore, Annie Grahl of Wisconsinites Abroad, and our chair, Candace Carriston, for furthering Wisconsin's Get Out the Vote efforts by sponsoring today's conversation. Please scan the QR code now to register and request your 2023 ballots. A reminder of why we're voting: Wisconsin has been inundated by dark money and MAGA candidates are on this ballot. Don't let Wisconsin get double-danned. Make it a fair fight. What's on your ballot? In District 8, there's a special legislative election. Be sure to mark your ballots for Jody. The Wisconsin Supreme Court election looms large before us. Please, please, please vote for Judge Janet Protasewicz. Did you know that during the last school year, 6 school districts banned 29 books? Luckily, we can reverse these trends by voting on our full ballot. Check every box. There may be a school board election in your district. Visit the Wisconsinites Abroad page to learn all you need to know to vote this cycle. The results of these elections will, again, affect Wisconsinites for decades and may even be a determining factor in voting rights, as well as who gets sent to the White House in 2024. One more time for good measure. If you live abroad, visit votefromabroad.org right now to request your ballot. Find our guides to learn how to complete your federal write-in ballot, also called the FWAB, and how to properly mail your ballot home at democratsabroad.org/WI-USA. Get out your ice-breaking gear, everyone, and help us restore the balance of power to create a fair Wisconsin by donating, calling voters, and connecting with us. You can follow Wisconsinites Abroad to repost our messages on Facebook and Twitter. Be sure to contact us at wi@democratsabroad.org. And please keep an eye out for our next events, democratsabroad.org/WI-USA. Thanks to everyone near and far who could attend tonight. We cannot wait to get out that vote in Wisconsin. Have a great night.